Welcome back to the deep dive. We're continuing our journey through the MPP, the Manual of Patent Examining Procedure.
That's right. We're trying to crack it open section by section and really pull out the key stuff for you.
Make it accessible, whether you're studying for the patent bar or you're already practicing.
Exactly. Sort of cutting through all the dense language to find what you actually need to understand.
And today we're jumping into Chapter 2100. That's the big chapter on patentability.
And specifically, Section 2190.
Right, 2190. It covers two really important doctrines, Prosecution Laches and res judicata.
Yeah, these might not pop up every single day in prosecution, but if they do apply, they can have a huge impact, like potentially fatal for an application or even a granted patent.
Okay, so definitely things you need to be aware of. They touch on, well, how you manage the whole process and what happens after a decision is made.
Absolutely. Understanding them is pretty crucial for, effective strategy.
Yeah.
And avoiding some major pitfalls.
So, our mission today is to unpack these two concepts from 2190. We'll look at what they are, mention some key cases, and talk about why it matters. Ready to jump in?
Let's do it.
Okay, first up, prosecution laches. What's the core idea here?
So prosecution laches is basically an equitable doctrine. It means that if an applicant, that's you, engages in unreasonable and unexplained delay while prosecuting the application,
Unreasonable delay.
you could actually end up forfeiting your right to get a patent on those claims. It's about sitting on your hands, essentially.
Unreasonable sounds a bit vague, though. Are we talking about, like, taking the full time to respond to an office action or something more?
Oh, much more than that. It's not about routine prosecution timing. It's reserved for what the MP calls egregious cases.
Egregious. Okay. Yeah.
Yeah, think about the case in Bogese. That's a big one here.
What happened in Bogese?
Well, the applicant filed 12 continuation applications, spread over about 8 years. And crucially, during that time, they didn't really make any meaningful progress. They weren't really trying to advance prosecution, just sort of refiling similar stuff again and again.
Right. So it wasn't strategic continuation practice. It just looked like delay for delay's sake.
Exactly. And the Federal Circuit looked at that pattern and basically said, yeah, that kind of behavior, that long period of unexplained, unproductive delay can lead to forfeiting your patent rights.
So it's not about a specific number of years or continuations, but the pattern.
Precisely. The MPA stresses there are no hard and fast time limits. It's about the overall conduct.
Yeah.
Did the applicant fail to move things forward when they had the chance? Was the delay unreasonable and unexplained?
Okay, so there's a difference between, say, filing a continuation to pursue different claims versus just stalling.
Right. And the courts have drawn that line. There's another case mentioned, Symbol Technologies v. Lummelson. The court there tried to distinguish legitimate continuation strategies, maybe waiting for related cases, pursuing different claim scopes from what it saw as abusive delay tactics, just meant to game the system.
That distinction seems vital. You don't want to penalize legitimate strategic choices.
Absolutely not. It's focused on the abuse of the process.
And I imagine an examiner can't just decide on their own, looks like laches to me. Is there a check?
Yes, and it's a significant run. Before an examiner can actually issue a rejection based on prosecution laches, they need to get approval from the Technology Center director.
Ah, okay. So it goes up the chain.
It does. It shows this isn't just a run-of-the-mill rejection. It's considered pretty exceptional, reserved for those really clear cases of unreasonable, unexplained delay that prejudices the public.
Good to know. That adds a layer of protection against it being used lightly. Okay, so that's prosecution laches delay during prosecution. But Section 2190 also covers something else. Res judicata. This sounds legalistic.
It is. Res judicata is a classic legal principle. The Latin means a matter judged.
Okay.
In simple terms, it stops parties from refighting battles that have already been definitively decided by a competent authority, like a court or an administrative body. It's about finality.
Finality. So bringing that to patents, does it mean if your invention was found unpatentable once, you can't just try again with a new application?
Pretty much, yes. The MPP explains it like this. An applicant or patent owner might be barred, stopped, from pursuing claims if those claims are not patentably distinct from claims that were already rejected.
Not patentably distinct.
And that rejection was upheld by a final decision. That final decision usually comes from the PTTA, the Patent Trial and Appeal Board, or maybe a court that reviewed the PTA decision.
And what makes a decision final enough for res judicata to kick in?
Good question. The case in Hitchings helps clarify that. For a decision to have this preclusive effect, this stopping power, there can't be any further appeal options left. It has to be truly done and dusted.
Okay, so appeals exhausted, the decision stands. Got it.
Mhm.
Does this only apply to the claims themselves? What about other parts of the application?
Interestingly, no, it's not just claims. Section 2190 notes that res judicata can also apply to amendments to the specification or drawings that were denied in a prior proceeding.
Oh, really?
Yeah, if the written description part, the disclosure, is essentially the same in both the old application and the new one. It stops you from trying to sneak back in changes that were already rejected, assuming the underlying technical teaching hasn't changed.
That makes sense. Prevents doing an end run around a prior decision. So to really get a handle on this, maybe some examples would help. The MPP usually cites cases.
It does, and they help show when it does apply and when it doesn't.
Okay, so where has it been successfully used to bar claims?
Well, the MPP points to cases like Edgerton v. Kingsland and also in Recats. In those kinds of situations, the applicant came back with claims that were considered either identical or, crucially, not patentably distinct from claims that had already been finally rejected in an earlier case.
So the court or the board basically said, we've already decided this specific subject matter isn't patentable, issue closed.
Exactly. Res judicata blocked the applicant from getting another bite at the apple for essentially the same invention.
Okay. But what about the other side? When does res judicata not apply? It can't be automatic every time there's a related prior case.
Right. It's very fact-specific. The MPP mentions cases like in Refried and in Rehelbaum as examples where courts said, no, res judicata doesn't apply here.
And why not? What was different?
Usually it boils down to one of two main reasons. Either the claims in the new application were found to be substantially different, patentably distinct from the ones that were finally rejected before.
So genuinely new scope or features.
Or the applicant presented new evidence of patentability, something relevant that wasn't considered or maybe wasn't even available during the first go-around when the final decision was made.
Ah, okay. So if you can show your new claims are truly different or you have new persuasive evidence, you might overcome it.
That's the idea. It shows it's not just a blanket ban. The specifics matter a lot. How similar are the claims? Was the prior decision truly final? Is there genuinely new material evidence?
How different do claims need to be? Is there a clear line?
Not really a bright line, no. It's a judgment call based on comparing the old rejected claims and the new ones, more than just minor tweaks in wording. They need to define a patentably distinct invention.
And the new evidence, what kind of stuff counts?
Typically things like new test data showing unexpected results, maybe evidence of commercial success that arose after the first decision, or perhaps new arguments based on prior art that wasn't previously considered. It has to be relevant to the new claim's patentability and something that couldn't have been reasonably presented earlier.
It really underlines how important careful claim drafting is, and also keeping track of all potential evidence throughout the whole process.
Absolutely. These cases show you need to look closely at the claim language, the finality of the prior ruling, and any new information.
So let's tie this together. What does this all mean for you listening in, whether you're prepping for the exam or deep in practice?
Well, understanding these two doctrines is pretty fundamental, even if they aren't everyday rejections.
Right. Knowing about prosecution laches warns you about the risks of, well, letting an application languish without good reason. It encourages keeping things moving.
Definitely. Avoid that egregious delay label. And understanding a res judicata helps you strategize. If you have a prior negative decision, you know you need to make sure any new claims are clearly distinct or backed by strong new evidence. It shapes how you approach follow-on applications or even challenges.
So this deep dive, like the others in the series, aims to give you those core ideas and the key case examples concisely, just the essentials from the MPP text.
Trying to cut through the noise and give you the practical takeaways efficiently.
Okay, I think that covers the main points of MPP section 2190. We talked about prosecution laches. That's the penalty for unreasonable, unexplained delay, thinking of Bogese.
Right, and the simple technology's distinction between legitimate and abusive delay.
And then res judicata, stopping the relitigation of finally decided issues, with cases like Hitchings on finality and Edgerton, Katz, showing where it applies.
And Fried and Hellbaum, showing where it might not apply, if claims are distinct or there's new evidence.
You know, thinking about them together, it really highlights how much your actions during prosecution and the outcomes of those actions can ripple forward. Procedural history really matters.
It absolutely does. Every strategic choice, every response builds that history, which can impact things later on, sometimes in ways you didn't expect. Something to keep in mind.
Definitely something to mull over. Before we wrap up, we want to thank Mike Shepard. He's the creative director behind this series.
Yes, thanks, Mike. And we also need to include our standard disclaimer.
Right. Important note. This summary was put together using AI tools like ChatGPT and Notebook LM. It might have errors or leave things out.
Yeah, it's really just for general educational background. It's definitely not legal advice, and it's not a substitute for actual formal instruction.
For the official word, you always need to go to the official MPP itself or consult with a qualified instructor or, of course, a registered patent practitioner.
Please do use this as a starting point, maybe, but do your own deeper dive.
Absolutely. We hope this was helpful, and we encourage you to keep exploring these MPP sections.
Thanks for tuning in.
We'll catch you next time for another deep dive breakdown.